Good evening, everybody. Thank you for joining us. Thank you for joining us for tonight's B.E.A.T session. Tonight, we are going to be talking about rules, regulations, and how those are going to be affected by the current pandemic. Our presenters tonight are Tracy Danner-Bond. She is a partner with the firm, working out of our Plymouth office. She works on all sorts of condominium issues, document rewrites, FHA certifications, and does estate planning as well. And Mr. Shane Deal, who splits his time between our Plymouth and Mount Clemens offices, and again works for, does all the condominium issues and violations, collections, and does estate planning as well. So welcome. Thank you for joining us. You'll see I'll be hosting on Facebook. For those of you who don't know me, I'm Stacia Miller. I'm one of the attorneys out of the Mount Clemens office. And Melissa Francis will be hosting here on Zoom. And for those of you who don't know her, she's one of the associate attorneys out of the Plymouth office. So I hope you enjoy the session. And if you have any questions, feel free to chime in. Melissa?
So I just wanted to let you know, if you are on Zoom, you can drop your question in the public chat. Then I will ask that question of our presenters when there is an appropriate pause in the presentation, and they will answer it. If you would like a copy of the presentation and handout and the article that will be mentioned in the presentation, please send me your email, and then I will email you those documents after the presentation. If you're on Facebook and you have a question, you can put your question in the Facebook Live chat box, and Stacia will ask that question of the presenters for you. Additionally, if you are on Facebook and you would like the documents, just pop your email in Facebook and Stacia will get those to you. So without further ado, I'm going to turn it over to Shane.
Thank you, Melissa. Tonight we are talking about rules regulating amenities during the COVID-19. We're going to talk about why we might want rules and what kind of rules we might want. But the first thing we're going to talk about is what is the difference between rules and regulations and bylaws. And condominium bylaws typically govern how the condominium corporation is run. They address matters such as the election of the board of directors, collection of assessments, or how the rules are passed. Condominium bylaws also govern the condominium complex, as we will talk about momentarily here, every condominium must have a set of bylaws. Rules, on the other hand, kind of supplement the bylaws. The rules focus on the day-to-day concerns of the condominium and condominium living to help make sure it's a pleasant place to live and work. They clarify what in many instances can be some confusing bylaws. So we're going to talk about why we might want to have rules rather than passing a bylaw. Let me tell you that there are several major differences between rules and regulations. One of the major differences is that number one, your bylaws are required by, excuse me, your bylaws are required by the Michigan Condominium Act. Section 53 of the Act requires that associations be governed by bylaws. There is no real provision in the Condominium Act for rules and regulations specifically. And also important with regard to rules, with regard to bylaws, is that they're recorded. Being recorded, that gives notice to the public, and more importantly, it gives notice to the co-owners as to what those bylaws are. We'll talk a bit more about that in a moment. The big difference between rules and regulations and bylaws is that bylaws require that you have 2/3 of your membership in order to pass a bylaw. So if you want to make a change, or you want to clarify, or you want to do something with your documents that that is going to be long lasting and permanent, probably want to think about maybe changing the bylaws, because once it's in, it's in there for a while. Again, you have to have 2/3 of your members in order to make that change. On the other hand, rules can be simply enacted by a majority of your board of directors. So if it's going to be something maybe short term, or maybe something that's clarifying the bylaws, or something that may change in the future, you may want to look at just passing a rule rather than amending your bylaws. Okay, so change the screen slide. I'm not getting any slide changes. So I'm going to assume that our slides are changing. Let me take a look at something real quick here, folks. All right. All right, so rules and regulations are used to clarify and expand on bylaws. And so you kind of want to think of bylaws as, if you want to do it very simply, think of bylaws as like the US Constitution. Big, broad stroke regulation covers, you know, it covers all the big stuff, all right? And then the rules and regulations fill in the gaps. Think laws and statutes, okay? And so, so if you get confused about which is which, just think of the bylaws as being the really big rules, and the rules and regulations as being the ones that fill in those gaps. Change the screen. So rules and regulations are used to clarify and expand on bylaw provisions. You generally can't have a rule if you don't have a bylaw to start with. So, so you just want to make sure that before you start making rules, you go through your bylaws and you look to make sure that you have some sort of bylaw to start with that you're using to clarify and to assist in interpreting that bylaw. One of the important things that you want to keep in mind here is that if there is a conflict between a rule and a bylaw, the bylaw, being the broader stroke, always overrules whatever a rule might be. So we can go to the next slide. So who has the power to create rules and regulations? Most association documents have these provisions in them, in the bylaws. Typically, you'll find in the restrictions section of the bylaws, there will be a provision which will indicate that you know, something to the effect that it is intended that the board of directors of the association make rules and regulations from time to time to reflect the needs and desires of the majority of the owners in the condominium. And that might be the entire provision that you will find in your bylaws with regard to making rules and regulations. Other bylaws may go on and indicate how the rules may be enacted, or, you know, it might say something like these rules have to be distributed 30 days before they become effective. There may be other terms within that provision. The other section that you will find typically in your bylaws is in the Board of Directors section where it tells about the duties of the Board of Directors. And that section is going to typically indicate something to the effect that the board has the ability to make and enforce reasonable rules and regulations in accordance with the bylaws. You want to make sure before you start making rules, before you start trying to enact rules, that there is a provision in your bylaws which allows the board in order to do that. Typically, like I said, you'll find it in a couple of different spots in your bylaws, but you want to make sure that what the requirements are for making your rules and regulations. Rules and regulations can be changed by the board when circumstances change. We're going to talk a lot about circumstances having changed. Tracy's going to talk a lot about that this evening, especially circumstances such as the COVID-19 and how it's affected associations and why they are and why the COVID-19 is requiring or may move the board to make some changes in your bylaws. So more on that coming up. Provisions in the association's bylaws often can be rescinded by a majority of the co-owners. I have seen provisions. In fact, I think the one that I just looked at momentarily just a minute ago, yeah, this is the one that requires actually 2/3 of the members in order to overturn or rescind a rule that was created by the board of directors. But in most cases, and I would say, I've only seen that one time. In most cases, the rescission provision is found in the bylaws, and it will typically be just a simple majority of the membership, not of the board of directors, but a simple majority of the membership is required to overturn a rule or a regulation created by the board of directors. Next slide, please. Any questions? Okay, so what about policies? Policies are meant to govern board's actions. These are typically internal types of documents, internal types of regulations that govern the board of directors on how they may conduct meetings or how they may enforce some provisions of the bylaws. You may think a confidentiality agreement would be a policy that would be addressing just the board of directors themselves. Collection policies, when do first letters get sent out? When does maybe a collection matter get sent over to the attorney? That's a policy that the board adopts, which allows the board then to have some guidance as to how they should operate in administering the association. Excuse me. Next slide, please. So how do we choose whether we need a bylaw or whether we need a rule or a regulation? And I think the best way to really do that is to just think fluidity. Think if you want a rule or a regulation, you want something that maybe you can enact quickly and that maybe doesn't have permanence. If you want permanence, think bylaw. If it's a controversial circumstance, most likely you're going to want a majority of your members to vote on it. think the bylaw. If you want to put new buyers on notice, think the bylaw. That's where the recording comes in that I was talking about a minute ago. When the master deed gets recorded, the Exhibit B of the master deed, which is your bylaws, also gets recorded with it. That puts then anybody, the general public, on notice of what your bylaws are. Anybody can obtain a copy of the association's bylaws by going to the Register of Deeds in which in the county in which the association that the condominium is located, and they can get a set of those bylaws to find out what kind of bylaws that particular association has. But if you want something, if you need something that's relatively fluid, you need something that needs to be done relatively quickly, then in that circumstance, rules or regulations are exactly what you're looking for. Circumstances could change. Obviously, the COVID situation, which Tracy's going to talk about in a moment, it's not a long-term thing. It's probably not going to last forever. I hope it's not going to last forever. And therefore, rules that you might pass now relative to COVID-19, you may rescind sometime in the future. So you want that fluidity with regard to rules and regulations. So at this point, I'm going to turn this over to Tracy.
All right. So with the rules and regulations, this is where the board of directors has the ability to address COVID-19 issues. In light of COVID-19, we need to think about how to deal with common areas and common amenities. So the next several slides, we're going to go through and talk about what types of rules and regulations you could have for these different common areas or common amenities. Next slide. Your condominium complex has apartment-style buildings where you have shared hallways and building entrances. This list is a good start for your rules and regulations for those areas. Now, before we get into all the details, just want to remind everyone that the governor has the mask requirement now. So this is in addition to wearing the mask, we're going to be talking about these other rules and regulations. And currently, the indoor public space, you must wear your mask, as well as outdoor when you cannot social distance at 6 feet. And currently, indoor gatherings are still limited to 50 people, and outdoor gatherings are limited to 250 people as of the Executive Order 2021-15. So if you do have the hallways and building entrances that are common areas, you might consider rules and regulations that include maintaining social distancing, limit loitering and congregating in those common areas. If your building allows it, have ingress and egress doors to provide with one-way traffic if possible. If you've got a lot of folks moving in and out, so maybe you have a community in Ann Arbor, it's doubtful that the students are going to be moving in, but if you had a situation where a particular weekend was very popular for move-in, you might consider having a schedule so that fewer people are coming in and out, not being able to social distance. And if residents are aware of someone with COVID-19 that has touched common areas, do request that the residents report those areas so they can be deep cleaned. Next slide. Laundry rooms and elevators. Again, these are limited to those communities that have these common areas. Again, simple rules and regulations limit the number of people in that area. You could limit the number of people that are using that laundry room per day or per hour. Or if you walk in and you see that there are 20 people, come back a different time. Elevators, again, that's going to be tough, but you can limit the number of people in those elevators. Maintain your social distancing, remind folks to wear their masks, because again, this is going to be considered a public space where you do need to wear a mask. And again, request that residents report any areas that need to be cleaned based on exposure to the virus. Next.
Tracy, in addition to move in, move out rules and schedules, do you recommend possibly having schedules for contractors, delivery people, caregivers, and real estate agents?
That's going to be more challenging. I would recommend that the co-owners contact the property manager to let them know if they've got strangers coming into their buildings. I don't know how you could schedule real estate agents or caregivers. I mean, they're generally going to be coming in at a certain time. So if you find that there are a lot of folks coming in and out, you may want to contact the property manager and just see if there's a way we could schedule, but I'm not sure that would be a reasonable request to make of the co-owners. Good question, Melissa. Thank you.
And the other question that we have is, if they make small changes to their bylaws almost every year, how often do they need to update the attachment to the master deed?
The attachment to the master deed is going to be your bylaws. So as Shane mentioned, if the bylaws need to be amended, that's going to be on an as needed basis. The rules and regulations that we're talking about right now are in response to changes in circumstances, especially something like COVID-19. So how often you revise your bylaws just depends on how things change within your community and changes that cannot be done through rules and regulations. Next slide. Mailbox clusters. If you have mailbox clusters, and most communities have some type of mailbox clusters, some rules that you want to consider having is going to be maintaining social distancing, limit loitering and congregating in the common areas, and request that residents report areas that need to be cleaned based on exposure to the virus. I know that Stacia recently received some questions about, well, who's responsible for cleaning those mailboxes, even though the community doesn't own them? And that's a great question. As we all know, the post office actually owns those mailbox clusters. But in light of COVID-19, they don't have the manpower to go through and clean those mailbox clusters. So if you happen to have Clorox wipe, you want to wipe it down, great. I don't think that it's reasonable to require that the association do it on a regular basis if they don't have an on-site person. But for those communities that do have an on-site maintenance person, you may want to add that to their list of daily chores and things that they do throughout the community. Next slide. Pools. This is a big topic. So big, Melissa Francis drafted a blog. It's posted on our website in our special COVID-19 section. On June 15th, she posted that blog regarding opening your pools. And there was a big discussion also in our June 10th webinar that Greg Fiorito, Ed Zelmansky, and Ed Castellani from Fraser Trebilcock participated in. So we really recommend that you look at our website page that has our special COVID-19 section and review the section, the blog that Melissa did on opening your pools. It is our recommendation at this time that communities do not open their pools, but if you do choose to open your pool, you really need to have some rules and regulations in place. Make sure that the CDC guidelines are included in those rules and regulations, the state of Michigan guidelines, and any other municipality guidelines that are in your community. Limit that use to residents only is our recommendation for another rule. Don't allow guests. Social distance, only allow the residents limited, plus the essential workers and those other people that need to be there based on board of directors approval, such as other contractors that need to work in that area. Again, we would recommend if you're going to open up your pool, if you can't maintain social distancing, wear your mask at the pool. And again, reporting those areas that need to be deep cleaned is a big thing. So again, check out our blog, check out our website with the special COVID-19 sections on pools if you do choose to open the pools. One statistic we did receive, the Community Association Institute did a survey, and I don't know how many of the communities within the nation did respond, but of those that did respond, they said that as of July 9th, 41% of the pools did not open due to COVID-19. So again, I don't know how many people responded to that survey and what percentage of the folks in our nation that have condominium associations or homeowners associations, but just obviously not everyone is opening up their community pool. Any questions on pools that came through, ladies? Okay, next slide. Clubhouses. If you choose to open your clubhouse, some of the rules and regulations you should consider is to limit the number of people. This is considered a non-essential amenity. Limit the use to residents only. We don't recommend that you have graduation parties or baby showers or retirement parties at this time, just simply because the virus is still such an issue. Maintain social distancing. We consider this to be a public space for terms of mask wearing. So please put your mask on when you do go in those areas. If you can identify one-way direction pattern flows, and if you have two doors, maybe you can do exit and enter to create less contact going in and out of the clubhouse. And again, requesting those areas that need to be cleaned, report those to the property management company. Next slide. Fitness rooms. We recommend that associations follow the requirements or the requirement by the governor right now that gyms do not open at this time. But if you choose to open your gym, the rules and regulations that you should consider, again, are limiting the number of people. People should be wearing their masks in those enclosed areas. Limit use to residents only, plus essential workers and those deemed necessary by the board. Maintain your social distancing. No loitering, congregating, one-way traffic flow. You may also want to add requirements and cleaning supplies that each person wipe down the equipment that they use after each use. And certainly if you know that someone with the virus has been exposed to that fitness room, let the property management company know so they can close it and give it that deep clean. Next slide, please. Tennis courts. We believe that you can open your tennis court safely. You don't have to, but if you do choose to open your tennis courts, you should consider limiting the number of people. Again, residents only, no guests. That's going to keep the numbers down. Maintain that social distance. Even consider wearing masks, although I think that'd be a little bit challenging with that type of physical activity. No congregating or loitering, and those deep cleaning requirements if you do know that that area has been exposed to the virus. Next slide. Playgrounds. This is a tough one because do you clean it after every use? Do you not? I know my children would love to go to the local playgrounds. So if you want to keep those playgrounds open, you might want to recommend to the residents that they bring their own wipes. Obviously, if you know that someone's been exposed with the virus to the playground, contact the association for that deep clean. But again, just like with the other amenities, limit the number of people, residents only, social distance, and we would also add that mask requirement if you can't social distance, even though you are outside. Parks and recreational areas. This one is a little bit easier for folks to open just because it is outside and you're more likely to maintain that social distance without any issues. We don't want to have big groups gathering, although they can up to 250 people. We do want to keep it down for these communities just to keep the risk down. Questions have been addressed regarding barbecue grills. Use of barbecue grills would certainly be fine. You may want to add a rule and regulation to wipe the grill down before and after your use. And pavilion use, that was also another question that I believe Stacia had received from one of her association clients. I think that pavilion use would be fine as long as you have proper rules in place regarding the number of people based on that size of that pavilion. I think that masks should be required if you're not able to social distance, even though it is an outside area. Next slide. Shane?
Okay, so what is the process? How do we implement and adopt these rules and regulations that we have or that we thought about putting together. Next slide, please. First thing we have to do is identify what it is that we want to enact. What is it that we want to do? We want to be as specific as possible in adopting this rule. And so we want to narrow it down to what do we want to get out of this rule? What is the function of this rule going to be? So we identify it, we draft it, we determine this is what our rule is that we want to have, and then we move forward from there. Now, if this is a new association, maybe you don't have any rules at all. And if that's the case, then you may want to put together a committee of co-owners within your complex, and kind of get a feel for what everybody in the complex would like to do as far as these rules go, and then have that committee then make recommendations to the board of directors with regard to those rules, and then they can draft those rules, and then send them off. First thing you want to do, send them off to the association's attorneys so that they can review those rules and regulations to make sure that, number one, there's a bylaw that supports it, and that they are not in conflict with the bylaws, and that they're not in conflict with any other laws or any other regulations that may be out there. So once the attorney's taken a look at it and they have signed off on it, then it goes back to the board of directors. And the board of directors then will vote on that at a duly noticed meeting. They will vote on the rule, and if a simple majority of the board agrees that rule should be passed, then that rule would be implemented. And the next step you would take is to distribute that rule then to the members. Now, typically, you have 30 days or so to get these rules out. But with these new COVID-19 issues coming up, these rules can be given effect immediately. These are health and safety circumstances, emergency circumstances that would require that these rules be allowed to be implemented immediately. Rather than waiting for a period of time. But given that they are being implemented immediately, we want to post these new rules and regulations in high traffic areas in the community. One of the primary areas that we're going to want to post these rules and regulations is right in the area that's affected. If it's on the clubhouse, if it's on the pools, if it's on the tennis courts, if it's out at the gazebo, wherever the rule is going to affect within the complex, we want to make sure it gets posted there, as well as any other places that it may be required to be posted by the state of Michigan or the federal government. So next slide, please. All right, so one of the things, in fact, one of the primary things that you want to make sure is that the rule that you're passing, the rule that the board wants to implement is reasonable, and not, the term is arbitrary and capricious. That is the term used by the Court of Appeals. It's been used by a lot of different courts to strike down rules. Arbitrary generally means random. Capricious means unpredictable or impulsive. But the rule must be reasonable. The Bear Creek case had a circumstance where they prohibited dogs weighing over 40 pounds and standing more than 18 inches in height. why it makes a difference whether the dog is 18 inches tall or not. And is that 18 inches at the shoulder, 18 inches at the top of the ears? You know, it just didn't make a whole lot of sense. And the court looked at that and said it would be unreasonable and arbitrary. And so the court struck down that rule. Next slide, please. Okay, so how do we enforce these rules? You've seen the governor's rules and what she's asked people to do, and you've also seen that a lot of people have ignored those rules, and sometimes people just do that. They just think, the rules are for those people, they don't apply to me. Or maybe they just feel like, wow, that rule is just, I just can't follow that rule. Well, if you have, you know, a co-owner within your complex who just doesn't seem to get it and won't follow the rules, you would enforce these rules in the same fashion as you would enforce your bylaws. Your bylaws typically say that co-owners are required to abide by the terms of the master deed, the bylaws, and the rules and regulations that are adopted by the association's board of directors. And so you can enforce those rules and regulations in the same way that you would enforce the master deed or the bylaws. You may send out a first letter to these people, you know, and just say, hey, you know, we notice that you're not abiding by the terms of this rule. You know, we're just giving you notice that we're aware of this and that you need to abide by the rule. If that doesn't get to them, and after several notices, they just still don't get it, and it's a terribly egregious situation, you know, maybe you fine them under the terms of your fining procedures in your bylaws. You can do that. And if fining doesn't get the point across, and it's an egregious situation, and maybe it caused damage as a result of not following the rule, you can take them to court. You can file a lawsuit against them to have them obtain a court order enjoining them from violating the rule and requiring that they abide by the terms of that rule. So let's just kind of keep that in mind, though, that going that far with regard to enforcing the rules, that's an expensive proposition when you get to taking legal action. So, and maybe all you want to do is just send a legal letter. That might be just the best thing to do. Just have your counsel, your legal counsel, send a letter to the co-owner saying, hey, you're not following the rules. The association could take you to court. They would rather not, but if you don't follow the rules, they will do that. So you do have all of the powers within your bylaws that you would have for enforcing the bylaws. You have those same powers to enforce your rules. Tracy?
Shane, before we go to Tracy, question, and
Sure.
either one of you or both of you can answer this. The question is that if the documents, for example, say that there can be no RVs in the complex, could you make a rule or regulation that would allow it to be there, or an RV to be there for 48 hours for load and unload only?
You know, I guess I would say it's possible, but it would really depend on how the language of that rule specifically says. If it flat out prohibits them in the complex, and we get this question quite often, and honestly, if the bylaws say no, you can't do it, and you want to pass a rule that is in conflict with the bylaws, you set yourself up. Unfortunately, you do. You set yourself up for getting into real trouble, because the co-owner can take that and they can say, hey, you know, the board's been letting these RVs in here. The bylaws specifically say that that there shall be no RVs in the complex. So I'm going to say, if you do that, just be aware that you're setting yourself up for somebody to complain about it and perhaps take the association to court with it.
I do want to add to that, a lot of the vehicle provisions of it's usually Article 6, the restriction section of the bylaws, often that provision will include some language that does permit the board of directors to designate certain areas for parking of vehicles. Your documents may or may not have that language, but if their language is in your bylaws, then it's my opinion that you can have a rule and regulation allowing temporary parking. But as Shane mentioned, if it's absolutely, your documents say you cannot have RVs in the community, maybe it's because of a parking issue. Maybe the community has a cul-de-sac and there's no way that you can turn these vehicles around and still have a fire lane open. I've been to a community that was exactly like that, and that's why they couldn't allow the RV parking. So really take a look at your documents, and if you're not sure, ask your legal counsel to give an opinion on whether that can be considered a rule and regulation.
Absolutely.
So in light of COVID-19, can the board of directors enforce the association documents? Absolutely. Just because this pandemic has hit does not tie the board of directors' hands with respect to enforcement. Review your documents. As Shane mentioned, there's going to be language in there about enforcement of the rules and regulations. As Shane mentioned, it's most likely going to be enforcement just as you would in the bylaws. Normally, that enforcement section is going to be toward the end of your bylaws. Absolutely get your property management company involved, get your property manager involved. Let them know of that bylaw or rule violation immediately so they can address the situation. If they're not able to resolve it, you may need to have your legal counsel step in and send a separate bylaw violation notice. Especially with the COVID-19 issues, if you've got a violation of one of these rules and regulations, you've got to jump on it right away so that you're making sure that the health and safety of the community is put first. Next slide. In light of COVID-19, the board of directors may want to consider relaxing some of the rules and regulations. Maybe you've got some rules that talk about no commercial vehicles. Well, I know that during this pandemic, some of the essential workers from DTE or Consumers Energy were driving their vans home. If you've got a community that says no commercial vehicles, in light of this pandemic, you could have a rule and regulation for a temporary time period that does allow the commercial vehicle parking for those essential workers. The other issue is kiddie pools. Say you've got a restriction that does not allow any outdoor pools in your community, but yet the community pool is going to be closed. So you could have a rule and regulation that allows the temporary use of kiddie pools by the co-owners. Again, you can have that be for a time period. So the summer of 2020, during the COVID pandemic, these rules and regulations are in place. You can have a starting date and an ending date. So it is possible to relax some of your rules in light of the pandemic. Next slide. We put together a list of resources here on this last slide that you can go to. Obviously, we talked about our COVID-19 support center on our website. We've got a lot of great information there. We've got the link to the State of Michigan website and all the other community websites. The Community Association Institute website is a source of a lot of great information about how to handle COVID-19 within your community. You've got those tennis courts and swimming pools. Those two websites for USA Swimming and US Tennis Association will offer some recommendations, as well as the CDC guidelines and the World Health Organization websites. Next slide. Any more questions that we can answer that came through, ladies?
There are not any more questions from Zoom at this point. Don't be shy, speak up, ask questions. Stacia, any questions from Facebook?
We have no questions from Facebook at this point.
If you need a copy of the resources, I'm sure that Stacia or Melissa can provide you with a copy of that sheet that was that slide that was just up there with those resources, and you can go there and get a lot of additional information.
Thank you very much, everyone, for joining us this evening, and have a great day.
And again, if you would like a copy of the presentation or the blog post, please, if you're on Zoom, drop your email to me and I will send that to you. If you are on Facebook, drop your email in the comments to Stacia and she will send that to you. And join us on August 12th at 6:30 for Managing the Unexpected, How to Handle Fire, Water, and Mold Losses, which will be presented by Edward Zelmansky and Richard Wagner. Have a great evening. Thank you so much for joining us.
Thank you.